Begin our thinking, prayers, and deeds with who? Divine love in the all. Abdor ku pazun tafulat watanabat mafu hadas ashuk fi anakalo. I am in the love of all, and now love is me. Anuki fi ina ashuk shel kalo wakol ashuk kaloni. We are all in all. Na athako na fikalo. I am a part of all, and all is a part of me. Anuki farugon shel kalo wakalo kalon farugon shel ni. I am one with all, and all is one with me. Anuki wahid kar kalo wakalo kalon wahid ma'ahni. I can succeed as part of all and fail as an individual. No kakilo anjiho kama farugon shel kalo wakok kama farudon. I can be all that I wish in all, as long as my wish is to stay in all. No kakilo wakwino ko tik no kakpizu fikalo kama taul kama kafazi kalonia ahmidu fikalo. I am never alone. Anuki kapahawahud. All is I am. Kalo kalon anuki. All can I can. Kalo yakol no kakilo. All does I do. Kalo bamol no kakmilo. Huamana.
Kawan fin.
Kawan fin. Kawan fin.
Kawan fin.
If you want to learn the the all affirmation, search. It's in several scrolls. One being the Asat scroll. Okay. You might get the word palum, like I said before. Comes from an ancient word. Palu meaning all, everything, totality, all. And then palum, the at the end of it is just like later on when it becomes a Semitic language, the I am sound, making it plural, denoting a definite article, the, all, right? And that means the many things, your awareness of many, many things seen and unseen within the all, plurality. But all as one, all is called. Okay. Another thing, all right. I've been on many platforms and expressed to the family, the tribe, the clan. They call themselves Sabaeans or Nuapians. And I've expressed that the master teacher is compromised. I even presented the question before several of them who are working on other parts of his freedom, supposedly working on other part of his freedom, namely stuff that are going outside of the United States and stuff. And I asked that question in a clubhouse: can the master teacher and my father be compromised? And it got quiet in there, as if everybody was still religious, as if they was afraid to say the truth. So I asked it in a different way. I said, okay, when the master teacher was standing before the judge, and it's on recording, and he looked out of it because of his torture, because of them having him drugged up, have his wives and children hostage, and tried to force him to say he was guilty. Could you say that at the moment with that guilty plea that he was compromised? One brother stood out, said, yes, I could say he was compromised. My intention was to break the spell of ignorance, as if the master teacher cannot be compromised. And for them to prove themselves that he was compromised, meaning that he can be compromised. He's in a compromising situation right now. Right now. He was in a compromising situation when they shot up his car, when they shot up with, what do you call them, beanbags or whatever? and threw him on the floor over there out of the truck, and then arrest him and took the children from the land. He was compromised. Okay? When they took all the babies into their custody and try to coerce some of them. This put the master teacher in a place where he has to make a choice and say things that he normally wouldn't agree to for the sake of others. And this same energy is still happening now within this place that everybody called their tribe. Okay? Everybody can agree that the master teacher was charged and convicted of racketeering. Can we agree on that?
Wow.
Can you hear me?
Sure. All right, so if you know about Title 18, 1961 through 1968, y'all do your research. You can learn about racketeering. So Neb, do me a favor. Go to your Telegram. I sent you.
Yeah, I seen it. I got you.
Pull it up.
Wow.
Pull up.
Yahweh Ben Yahweh was charged with racketeering, money laundering, and was given 20 years. He did his time, come out, and he could not have no more contact with his organization. That was part of his parole reading in Florida.
He couldn't have,
remember that day.
the master teacher or whoever else is on racketeering cannot have any type of communication or connection to the organization while
That is correct.
While in prison as well.
That is correct.
Let's set the record straight. All right. Anybody want to read? Feel free.
I'll read a little bit. Introduction. The primer provides a general overview of the statutes, sentencing guidelines, and case law regarding the Racketeer, Influence and Corrupt Organizations Act 1, commonly referred to as the Rico Act or simply Rico. This primer focuses primarily on application of the RICO guideline and related sentencing issues. Although the premier identifies some of the key cases and concepts, it is not a comprehensive compilation of authority, nor intended to be a substitute for independent research and analysis of primary sources.
Mm-hmm.
The statutory scheme, the RICO Act 18 U.S.C. 1961 to 68 provides for criminal prosecution of racketeering activities as part of an ongoing criminal organization. As noted in its legislative history, RICO is designed to address the infiltration of legitimate enterprises by organized crime and other illegal ventures. Some examples provided in this legislative history include the infiltration of legitimate businesses such as laundry services, retail stores, restaurants, and nightclubs or labor unions, to commit gambling, money laundering, loan sharking, or extortion. Leaders of extortion, tour. Leaders of criminal organizations can be held liable under RICO for crimes they order others to commit or assist in committing in furtherance of the ongoing criminal organization.
That part
As-
is very important right there. Can you read that little part again?
Okay, up to money laundering, leaders. Okay, leaders of criminal organizations can be held liable under Rico for crimes they order others to commit.
They order others to commit. Baba said this, and Baba gave me this, and Baba gave me this, connected to the same organization that he got in trouble that they labeled as him doing racketeering with. Okay? Corrupt organization they view you as, and that's what he's locked up for as well. Okay?
So.
And this whole Baba said this, and Partner Bab says that, and then his pictures, they are trying to implicate him. But let's continue. Appreciate it.
Or assist in committing in furtherance of the ongoing criminal organization. As discussed below, Section 1962 sets forth 3 substantive offenses and makes it a crime to conspire to commit any of the 3. Section 1961 defines terms used in the RICO statute, and Section 1963 establishes criminal penalties, including imprisonment, fines, and criminal forfeiture.
Seizing properties. Is the building actually being sold? All right. Is this a question? It could be. I don't know. I don't know why. It would make sense. Okay. So the first part that we just heard is just trying to get you to understand what each part is going to be talking about. All right? All the sections. All right. Hello.
Section 1962 A, B, and C sets forth the substantive prohibited activities. Section 1962 D makes it unlawful to conspire to commit any such prohibited activities. Each of the prohibited activities requires as a necessary element proof of a pattern of racketeering activity or collection of an unlawful debt.
Proof of a pattern, activity, same old pattern, books, no taxes, you hear me? A profitable organization that they're watching. Things are being mailed federally across the state line and across the waters to other countries. Let that marinate. All right, sister.
Where do you like me to read from?
Okay, scroll. Continue to scroll. Right here. Let's start on with 18, Title 18, USC, United States Code, subsection 1962A says.
Under Section 1962A, is a crime to use or invest an income derived from a pattern of racketeering activity or through collection of an unlawful debt to establish, acquire, an interest in or operate any enterprise engaged in or affecting interstate commerce. To establish an offense under Section 1962A, the government must show that the defendant had derived income from a pattern of racketeering or collection of unlawful debt, and then used or invested some of that income to establish or operate an enterprise engaged in or affecting interstate commerce. For example, a drug dealer violates Section 1962 by using the proceeds of a pattern of drug trafficking crimes to invest in or operate a legitimate business.
We've been propagating printing books, right? Since the 1960s, right? Propagating books being print all the way until now. The same pattern, etc. We used to say free will offering at that point, but that doesn't work anymore, right? He, master teacher, get kidnapped and incarcerated And yet the same pattern still happens. Affecting interstate commerce, this is the mail. And this is people traveling with books. Enterprise, you know what an enterprise is, right, y'all? Enterprise?
Bookstores.
Your bookstores. Everybody's wearing the same uniforms, same books, same this and that. That's an enterprise. Okay? So pay attention while I say people, some people are knowingly, yet others are unknowingly implicating the master teacher and making it very hard. This is going to get worse. This is going to affect everybody. This thing, once you read it, it's going to affect everybody. You're going to see how dangerous it is. That they could come at any time they want. All these new books. He's writing books. He's connected to the organization from in prison. He doesn't have a typewriter. I keep telling y'all this. If you say you're getting it from little pieces and letters and all of that, you got to translate it. You got to put it together. You got to proofread it. You got to do all of this stuff. You're not him. Therefore, secondhand, third-hand information. But still, on top of that, you're still saying that he is giving instructions, orders, commands from in prison while under the Rico. So number 2, we go to subsection
2 prohibits acquiring or maintaining an interest in or control of any enterprise that is engaged in or affects interstate commerce through a pattern of racketeering activity or through collection of an unlawful debt. This provision makes it unlawful to take over an enterprise that affects interstate commerce through a pattern of racketeering activity or collection of unlawful debt. For example, an organized crime figure violates Section 1962 by taking over a legitimate business through a pattern of extortionate and loan sharking acts designed to intimidate the owners into selling the business.
Selling the business. I heard that New York is about to be sold. Pay attention to this. Scroll down a little bit, Ned, for a second.
So, an organized crime figure violates Section 1962 by taking a legitimate business through a pattern of extortionate and loan sharking acts.
Over a legitimate business. It was legitimate. How many criminals is running this right now? I keep telling y'all. How many people running this nation, so-called nation that has criminal, federal, trying to change things? Anything, I keep iterating this, that was post his conviction, stop focusing on that and focus on his freedom. Let him say it to your face, his voice, where you can see it and you can know that he's there, it's him, he's free, and not under any type of duress or forcible coercion, being compromised. Go ahead, Nav, you can go to 3.
Section 1962 makes it unlawful for any person employed by or associated with any enterprise engaged in or affecting interstate or foreign commerce to conduct or participate directly or indirectly in the conduct of such enterprises' affairs through a pattern of racketeering activity or collection of unlawful debt.
All right, then. The key thing that I want you to highlight is affecting interstate. This is how feds come in, right? This is how he got his racketeering, right? Crossing state lines, mail, on their behalf, driving or mail. Interstate or what? Foreign commerce. They're not only implicating the master teacher, they're implicating you, the sincere ones. For example, employees of the New York State Department of Motor Vehicles violated this provision by using the DMV to process fraudulent license. You know what comes into my mind? When I saw a passport with my father's prison picture on it. Some so-called Liberian, he has an original one, where is it? The one from when Charles Taylor was president, before he became enemy of the state, therefore nullifying, destroying, depleting anybody else's who's under his administration position as well, like his diplomats, who Pops was one, who the master teacher in fact was a diplomat. I want y'all to marinate on that. But now they got post-conviction pictures and photos. See, the master teacher did not have white hair in his original beard. I mean, you know, in his original photo of his license, his passports. I have a copy. And everything else after his conviction is on these so-called, all these other passports, whether it's the one from prison, his prison mugshot, to the one where it was right before he got arrested, but after, years after his original passport. They didn't start doing and working on the passport until his incarceration. The master teacher had the opportunity to mention to the judge while in court, I am a Liberian diplomat. I am a Guyanese citizen. But did he? No, he didn't. What he said is, I'm a secure party, and he made reference to his Native American jurisdiction. Yeah, let's talk about it, right? Section 1962 requires the existence of two distinct entities, a person and an enterprise, that is not simply the same person referred to by a different name. Criminal liability depends on showing that the person conducted or participated in the conduct of the enterprise affairs. And every time Pops wrote this, he did that from prison.
Cool. Okay, so essentially this basically is saying, to say that the master teacher is writing those, any type of literature, whether it's an update, a scroll or whatever,
and making money off of it.
And right, it's a violation to just to even say he's doing it, and then to charge or collect monies on a, saying, he's the author of this, so conducting commerce or selling these literatures or whatever is a violation, not only for the master teacher, but even the person who's doing it on the outside. It's they are considered a criminal or engaging in a criminal activity or violations of the Rico.
Absolutely, this is my point. It's going to go there too.
Requires the existence of two distinct entities, a person and an enterprise that is not simply the same person referred to by a different name. Criminal liability depends on showing that person conducted or participated in the conduct of the enterprise's affairs.
How do you show that person was engaged or, within that affair? How do you know that how do you show that he was involved in all of that? He's in the Supermax. They read all the messages, they read all the letters before he gets them, before he receives them, unless it's legal, right? And everybody's on Facebook, everybody's on social media, Facebook, YouTube, TikTok, whatever else, saying it out loud. I got it from the master teacher. He said this and he said that to do this and do that, and he wrote this book and he wrote that book. That's how you get them. That's how you implicate them in it, and yourself. Hua. When I say hua, that means I land. You just say hua.
For purposes of Rico, a corporate employee, a natural person is distinct from the corporation itself. A legally different entity with different rights and responsibilities due to its different legal status, even where the employee is the corporation's sole owner. Likewise, the existence of an enterprise is separate from the pattern of racketeering activity in which the enterprise engages. The enterprise is proved by evidence of an ongoing organization and by evidence that the various associates function as a continuing unit, while the pattern of racketeering activity is proved by evidence of at least 2 racketeering acts committed by participants in the enterprise. However, evidence establishing the pattern of racketeering activity and evidence establishing an enterprise may, in particular cases, how do you pronounce that? Oh, I can't pronounce that, sorry.
Coalesce.
Yeah.
Scroll that. But as you can tell, what this is basically saying is neither the individual or the organization is immune from this.
Section 1962 provides that I or it shall be unlawful for any person to conspire to violate any of the provisions of subsection A, B, or C of this section, unlike this general conspiracy statute applicable to federal crimes, which requires proof that at least one of the conspirators committed an act to effect the object of the conspiracy.
Seems like we got more than one conspirators.
Section 1962 does not require the commission of an overt or specific act in furtherance of a RICO conspiracy. The RICO conspiracy provision focuses on the act of agreement. Therefore, a defendant who conspires to commit a substantive offense under section 1962 A, B, or C can be convicted of a RICO conspiracy, even without personally committing or agreeing to commit a racketeering activity or collection of unlawful.
Well, I even agreeing, even without what? Even without personally committing. The master teacher ain't do it. Or agreeing to commit racketeering. I wasn't trying to commit racketeering. I was just helping along. I was just helping to help the master teacher. Activity of collection or of unlawful debt,
as would be required for conviction of an underlying substantive offense, nor does a RICO conspiracy require proof that an enterprise actually existed or that a pattern
does not require a proof, y'all. It does not. This is how serious racketeering is. Woo. This is serious.
Or that a pattern of racketeering activity actually occurred. Rather so then how does that work though? How does that work? All right, rather it requires only that the conspirator intends to further an endeavor which, if completed, would satisfy all of the elements of a substantive criminal offense.
No, new organization in his name.
So does that mean that can just go by on the word of somebody else making an accusation against another person then?
Yes.
Hearsay. To a hearsay. You can be convicted of hearsay.
Wow.
They don't, the actual organization itself, you can't just say, well, that doesn't exist no more. That doesn't matter to them. You're gonna say the organization doesn't exist, we just being now, or however else you want to express it, that part doesn't matter. And everybody who are innocent, who's there for the master teacher, who's there for one another, everybody keep on saying there for the master teacher, and there for each other in Hadus Ashur, are being implicated as well. Who?
Rico defines racketeering activity as any criminal enumerated in subdivisions A, G of subsection.
Not any criminal. Not any criminal. Any crime. Start over again.
Oh, sorry. Okay. Rico defines racketeering activity as any crime enumerated in subdivisions AG of subsection 1 as any crime enumerated. Yeah, in subdivision AG of subsection 1, the listed crimes often are referred to as predicate acts. That's like predictive, isn't it?
Yes.
Plan.
So,
yeah,
say, instead of saying AG, you have to say A through G, so they'll know there's section out.
Okay.
Through G. Yeah.
Okay.
Well, you're good.
Because committing an enumerated crime is the foundation for a RICO offense. Criminal acts committed outside of the United States can serve as RICO predicate offenses, but only to the extent that the predicates alleged in a particular case themselves apply extraterritorially. Subdivision A includes any act or threat involving certain state offenses, including murder, kidnapping, gambling, arson, robbery, bribery, extortion, dealing in a controlled substance, and other serious crimes, punishable by imprisonment for more than 1 year. This definition does not list specific state statutes. Rather, as the Supreme Court has held, a state statutory offense may constitute a racketeering act under subdivision A, provided it substantially conforms to the generic definition of the state offense reference at the time RICO was enacted. Further, the statute restricts the listed offenses to those chargeable under state law, meaning that the offense must have been chargeable under state law at the time the underlying conduct was committed.
And it was. It was. One thing I want y'all to understand, something, this is a note for everybody. The master teacher was the very first federal, them trying the racketeering as a guinea pig within Georgia, within the state of Georgia, the very first federal racketeering defendant. The master teacher was. And then after that, you started seeing, after it worked on him, they started seeing them going after R. Kelly, Bill Cosby, everybody else. On down.
Okay.
Young Thug, I think his name was, right?
Wesley Snipes as well.
Young Thug.
He was the first master teacher. Do your research.
Subdivisions B, C, E, F, and G include any acts which is indictable under certain federal statutes These provisions are narrower than subdivision A because the act must have been indictable under one of the listed federal statutes at the time the subdivision was enacted. Attempts and conspiracies may not be used as racketeering acts unless they are expressively included within the terms of the statute. For example, a conspiracy to violate the Hobbs Act may be used as a predicate racketeering act under subdivision B because the Hobbs Act statute expressly makes conspiracy a crime. Excuse me, sir.
They can get you attempt, right? Alleged. You conspire. They're gonna say, yeah, you conspire. We got probable cause. That's it for everything too. Probable cause.
I have all these subdivisions. So subdivision D includes any offense involving listed categories of federal offenses. Unlike in subdivisions B, C, E, F, and G, the phrase any offense involving in subdivision D includes attempts and conspiracies. A pattern of racketeering activity requires at least 2 acts of racketeering activity, one of which occurred after the effective date of the Rico statute, and the last of which occurred within 10 years after the commission of a prior racketeering act.
Still going on right now, 20-something years, right?
Yeah, okay. The 10-year limitation excludes any period of imprisonment. As the Supreme Court has held, establishing a pattern of racketeering activity requires more than simply proving 2 racketeering acts within a statutorily prescribed time period. There also must be proof that the racketeering acts are related and amount to or pose a threat of continued criminal activity.
So how do you prove that it's related to the master teacher, y'all? How do you prove that? You see his pictures on everything? Does that mean that, does that connect them to these books and stuff from prison, so-called books from prison?
Wow.
You see his names? Father Babby, I know him, Dr. Malachi, yo. What y'all doing to the master teacher? They setting you up, realize how blind people are who are just gonna accept things. Like I said, woe unto you who do not follow our way of life, Unlawful. Ask questions. You moved away from that. Of course, and I'm not surprised that you can be fooled, because they said that the black devil, or that force, can fool the very elite. So, what is connecting him? Everybody. Baba said this, I got a letter, blah, 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 blah. Social media, YouTube.
Notice another aspect of it being like a religion, because, you know, in religion, you what do they say, like when you're praying, you always got your hand out asking for something.
Yeah, you accept things without knowing. That's belief.
Yeah, and then it's crazy. Because like even with them, you don't see them really caring about the master teacher. They just caring about what he can give to them, like new scrolls, you know what I mean? They're not even focusing. It's like, give me, but they're not really taking in consideration like what he's really going through. They just want something from him, you know? And it's like, and that's kind of like religious mindset.
What does religion have in common? Most religion. Don't it seem like all of them is waiting for something to come back?
Yeah.
Whether it's Jesus, whether it's Muhammad, whether it's Ahmadi, whether it's Yahshua, whoever else. And here we go, Sabine, waiting for Unlawful to come back. Unlawful is here. Always been here. Been right under your nose. Ooh.
Rico defines an unlawful debt as a debt incurred or contracted in gambling activity which was in violation of state or federal law, or which is unenforceable under state or federal law, in whole or in part as to principal or interest, because the laws relating to usury, that's usury, isn't it? Usury. And B, which was incurred in connection with the business of gambling in violation of state or federal law, or the business of lending money or a thing of value at a rate unserious under state or federal law, where the usurious rate is at least twice the enforceable rate. Thus, an unlawful debt is a debt that arises from illegal gambling or loan sharking activities. The prohibition on the collection of unlawful debt encompasses all efforts to collect on a usurious loan, whether by demanding payment in cash or by repossessing property pledged as collateral. While a pattern of racketeering activity must consist of at least two racketeering acts, the collection of an unlawful debt can be predicted on a single occurrence, such as the collection of a single unlawful debt. For purposes of the RICO Act, a person includes any individual or entity capable of holding a legal or beneficial interest in property.
Ooh. Y'all know about all that. All of these new foundations and incorporations with the, you know, with that they did with the organization, creating their own branches, all of that, but yet asking for money, demanding money. Look at Tabitha J. When. I love them. I need money. Look at all of these people. Implicating them. Playing with people's emotions. Make you feel a certain type of way. Make you feel guilty. That's a threat.
There's a lot of that going on.
Attacking people. You understand that? Character assassinating good people who put in their, who donated to help the master teacher in any way possible, and then ask them questions. What is going on? Or we're not allowed to tell you. Why? Because there are agents. Are you calling me an agent, nigga? I just put money in your hands. You're gonna look at me like you don't trust me? You can't tell me? I paid for that information. Stop putting your money in people's hands that act like they don't trust you. That's the dumbest thing that somebody can do. If they don't trust you, they don't respect you, they don't respect you, they don't respect the money. Here go why the master teacher is not out yet and there's not been a proper representation for him, but new books. You're paying for books. You're paying for prints. For them to print the books, and you're paying for their rent. I don't see any result until one of them come along and show proof beyond a shadow of a doubt. Become transparent. Stay in honor, integrity with the entire family. Until then, you're still a criminal. You're a criminal. You're shady. Cool.
An enterprise includes two categories of associations. The first category encompasses any individual, partnership, corporation, association, or other legal entity. The second category covers any union or group of individuals associated in fact, although not a legal entity.
Ooh,
Each category.
You heard that? Read that one more time.
Okay, an enterprise includes two categories of associations. The first category encompasses any individual, partnership, corporation, association, or other legal entity. The second category covers any union or group of individuals.
Who's that? The nation, the clan?
In fact,
Tribe?
hold on. Wow. Hold on.
Any individual associated. In fact, although not a legal entity, you're still being implicated. Neither organization nor individual are immune when it comes to racketeering.
Each category describes a separate type of enterprise covered by the statute, those that are recognized as legal entities and those that are not. Thus, the term enterprise includes both legitimate and I'm so tired.
Illegitimate.
No, it is. Yeah, over here it's like after 2 a.m.
That's fine. It's
2 a.m. in the morning. It's like my eyes are going blurred. Illegitimate. Is that illegitimate? Yeah, it's illegitimate. Illegitimate enterprises. I'm sorry. Excuse me. Okay. The enterprise referenced in the substantive offenses in section 1962 A and B is formed through an unlawful pattern of racketeering activity or by money obtained from an unlawful pattern of racketeering activity. By contrast, the enterprise referred to in the substantive offense in section 1962C is a vehicle through which the unlawful pattern of racketeering is committed. The Supreme Court has held that Rico both protects a legitimate enterprise from those who would use unlawful acts to victimize it, and also protects the public from those who would unlawfully use an enterprise, whether legitimate or illegitimate, as a vehicle through which unlawful activity is committed. Thus, under section 1962C, a legitimate enterprise may be the victim of racketeering activity.
Legitimate or illegitimate?
Okay, so the Rico Act establishes criminal penalties for a violation of section 1962. Pursuant to section 1963A, a violation of section 1962 is punishable by a fine. A term of imprisonment not to exceed 20 years or both.
Whoa. Each and everybody, that's both sides. Like I said, you don't have to be directly connected, but you are affiliated.
If the RICO violation is based on racketeering activity that is charged as a predicate act and has a maximum penalty of life imprisonment, the maximum penalty for the RICO violation is also life imprisonment.
Whoa. Now, yes. They can pick anybody up at any given time as they choose. They can pluck you. They can coerce you. They can tell you you can get a pass. And then they can implant you right back into the community. And you're over there talking about, I got a nice teacher. That's my husband. Whatever you want to do to continually implicate innocent people and force them to implicate the master teacher while he is compromised. When he's in a compromised situation.
So they become an agent.
That you better believe it. That's how people do. That's how they do. They work like that. And collecting data. You got people saying in certain groups, you must get your name and your social in order to join my group.
Oh,
in order to join their group.
Heard that.
Have you heard of that?
Oh, I've heard that.
Exactly. Name and social. Why would you need people's social, their information? Who you really working for?
Wow.
And you know who I'm talking about. They know who I'm talking about because that's their platform. Over there begging for money. Cool.
Yeah. In addition, Section 1963A mandates forfeiture of all involved property to the United States, irrespective of any provision of state law. This requirement includes any property, interest acquired or maintained in violation of Section 1962, any interest in security of claim against or property or contract right of any kind affording a source of influence in the Rico enterprise, and any proceeds from the racketeering activity or unlawful debt collection. Section 1963B specifies the type and nature of property subject to criminal forfeiture under the Rico Act, including real property and tangible. And
this is saying that everything belongs to them. All of your property, everything that you acquired, that they say that you acquired while in commission of this crime, this racketeering, whether
belongs to them.
It belongs to them. All that money is supposed to go to restitution. That's what they're going to collect it as. They will forfeit a lot of things from everybody. All your hard-ons, worth stores and everything at any given time they so choose to, when the time is right for them. And none of y'all know when the time is, but you can see how this is definitely a pattern of racketeering that everybody seems to be involved in. And like I said, maximum of 20 years, life in prison. That goes for more time for the master teacher and a new sentence for you. Let's keep it a buck. When you decide to start doing your research and your due diligence, you get to know what to do or what not to do. All right. Cool.
Intangible personal property and extends criminal forfeiture to any property that is subsequently transferred to a person other than the defendant, which is just what you said basically. Yeah. Under the transferee can establish that he or she is a bona fide purchaser. Section 1963D M sets forth certain procedures that the government must follow to dispose a property forfeitable, as in forfeiture, forfeitable under the Rico Act. Rico criminal forfeiture is imposed in addition to any other sentence for violation of Section 1962. A criminal forfeiture order is a part of the defendant's sentence, not part of the substantive offense of conviction.
They can add more time.
Yeah. Oh God. This is not even real right now, bro. I swear. Yeah, this is a lot, This is actually a lot. The double jeopardy clause prohibits successive prosecutions or punishments for the same offense. So there's a double jeopardy prosecution. The double jeopardy clause prohibits successive prosecutions or punishments for the same offense. Two offenses are separate, okay, if each contains an element not contained in the other. In the RICO context, double jeopardy issues may be triggered in two ways. A defendant is prosecuted for a RICO conspiracy and a substantive RICO offense.
What does that mean, huh? Double jeopardy is prohibited, meaning, okay, they can't use it for the same offense, but it could be the same. They can't use it for the same charges. You can't be charged twice on it, right? However, they can find something similar, that pattern.
Sure. Different areas.
But you changed the name. That's what they needed. That's all they needed. You changed the name now. Musbatia and all of that type of stuff, right? And then add Unlawful on it again. I'm just saying. If you're getting tired,
I have to laugh, you know. I have to laugh because if I don't, Sabak knows. Sometimes it's very heavy. It's very, very heavy to. It's very heavy. This is very heavy, basically, and sometimes it's unbearable. You know, sometimes it's unbearable, and that's just me who's not going through everything. If you see what I mean.
Mm-hmm.
So, it can get a little heavy. So, in the RICO context, double jeopardy issues may be triggered in two ways. A defendant is prosecuted for a RICO conspiracy and a substantive RICO offense. And two, a defendant is prosecuted for a substantive RICO offense and for offenses charged as racketeering acts underlining the RICO offense. The Supreme Court long has recognized that in most cases, separate sentences can be imposed for the conspiracy to do an act and for the subsequent accomplishment of that end. Because a RICO conspiracy contains a different element than a substantive RICO violation. Because a RICO conspiracy contains a different element than a substantive RICO violation. Namely, right?
Conspiracy and actually doing it is two different things, but you still get charged.
Sure. Crazy.
Okay.
A RICO conspiracy and a substantive RICO violation are not treated as the same offense under the double jeopardy clause. And accordingly,
Bing bong, you know what I'm saying? Right in your face.
Accordingly may be punished separately. It's heavy enough already, but they have a double jeopardy clause, right?
Right.
And it's heavy enough as it is, and they've still implemented that in there.
The RICO got a way around that double jeopardy clause.
Oh, okay. Okay, likewise, courts have held that a RICO substantive or conspiracy offense and its underlining racketeering acts are separate offenses for double jeopardy purposes and may be prosecuted separately and cumulatively punished. Furthermore, a jury's finding in an earlier trial, federal or state, that a defendant did not commit a crime does not preclude the government from later proving that he or she knowingly agreed to facilitate a racketeering scheme under RICO. The government may predicate.
It doesn't matter. Doesn't matter.
No, not at all. Not at all. It's like, yeah,
They'll come
the
back.
government may predicate a RICO conspiracy charge on acquitted conspiracy counts from a previous trial when a comparison of basic and RICO conspiracy makes clear that acquittal of the former does not compel the conclusion that a jury necessarily decided an essential element of the latter, because RICO conspiracy and basic conspiracy have qualitatively different mens rea. Different mens rea requirements, different mens rea requirements as to agreement and intent. Therefore, a jury's finding that a defendant did not conspire to commit a particular predicate act does not necessarily preclude a subsequent finding that he or she knowingly agreed to facilitate a racketeering scheme that involved or was intended to involve that same predicate act. The RICO Guidelines Section 2E 1.1 Unlawful Conduct relating to racketeer, influence and corrupt organizations. The guidelines instruct users to determine the applicable Chapter 2 offense guideline by referring to Appendix A, statutory index, for the offense of conviction. In example, the offense conduct charged in the indictment or information of which the defendant was convicted. For a violation of the RICO Act 18 U.S.C. I've forgotten what you said the U.S.C. means again.
United States Code.
United States Code 1962 Appendix A specifies the offense guideline at I think it's S2E 1.1 unlawful conduct relating to racketeer, influence and corrupt organizations. Section 2E11 instructs the court to apply the greater of two alternative base offense levels. There are no specific offense characteristics. Section 2E11 refers the court to other offense guidelines based on the underlying racketeering activity. The commentary to SE11 directs the court to look ahead to certain parts of Chapter 3 adjustments and in some instances to Chapter 4 criminal history to determine the appropriate offense level for the RICO offense. In many instances, the offense level for the RICO offense will be determined by the offense level for the underlying racketeering activity due to the wide variety of criminal conduct covered under SE11. Determining the offense level for a RICO offense.
And the word mens rea basically means criminal minded.
Criminal minded, okay.
Okay, that's what it means. Conspirators.
Yeah, that word. Word. Yeah, Section 2E11A specifies that the base offense level is the greater of 19 or the offense level applicable to the underlying racketeering activity. Section 2E11A establishes an alternative minimum base offense level of 19, a floor under which the RICO offense level may not be set regardless of the offense level for the underlying racketeering activity. As such, a RICO defendant's base offense level will not be less than 19. Okay.
Poor. Let me give a little explanation to that. No less than 19. In the sentencing guidelines, right? Racketeering is started at 19, which is, if I'm not mistaken, 360 months, which is a life sentence and above. Because you have minimum crime that starts at level 1, level 2, level 3, all the way up. But racketeering sentence starts at level 19, which is 360 months, which is 25 years. That's where it starts at. So you get no less than that for racketeering. Adios.
Relevant conduct, generally, section 1B1(3)(a) directs the court to consider all relevant conduct in determining base offense levels, specific offense characteristics, cross-references in Chapter 2 and adjustments in Chapter 3. Relevant conduct includes all acts and omissions committed, aided, abetted, counseled, commanded, induced, procured, or willfully caused by the defendant. And in the case of a jointly undertaken criminal activity, all reasonably foreseeable acts and omissions of others in furtherance of the jointly undertaken criminal activity.
Now look at that. Go back, Ned. Now look at that. Right? In that section 1B1.3a.
Sure.
To direct the court to consider all relevant conduct in determining base offense levels, specific offense characteristics, cross-reference in Chapter 2, and adjustment in Chapter 3. Relevant conduct includes all acts of omission committed, helping, that's another part, right? Aided, abetted, okay, counsel, commanded. He said this, he said that, he told us this, right? Induced, procured, or willfully caused by the defendant. So every time you mention his name and everything like that, just think about all of that. They can just throw on him. Okay? That's just, and then you have, and in the case of a jointly, that's the organization, together, undertaking criminal activities, what they would consider criminal activities, because of the fact that the master teacher is under the Rico, he's locked up under that. All reasonable, foreseeable act or omission of others in furtherance of the jointly undertaken criminal activities. You too, the organization. Cool.
In determining the base offense level applicable to the underlying racketeering activity, relevant conduct under S1B13 thus includes all activity that qualifies as a racketeering act under section 1961(1). Relevant conduct includes conduct that is charged or uncharged, as well as acquitted conduct. Thus, the underlying racketeering activity consists of any underlying offense, charged, uncharged, or acquitted, that qualifies under the statute as racketeering activity or collection of unlawful debt. By contrast, an act that may be within the scope of a RICO conspiracy cannot be considered in determining the offense level if it is not chargeable under a statute in section 1961.
All you gotta do is go back up in the video
and
reread the 1961 Title 18 USC.
So once they charge you with the racketeering act, you're practically trapped. There's no getting away.
It is very little room, I say. Very little room, isn't it?
No, it's not that many room. There's a way for him to be free, yes. Sure. There's a way he has to come out innocent. Innocent. That's what they have to do. He has to come out innocent. In other words, new evidence proving that there was some corrupt thing going on with the government or the court system, you know, that went against the master teacher, some judiciary misconduct, etc. And there is new evidence. This is what me and Adrian Patrick is working on. The real ones. Not something going back into no archives and going back into the, you know, the case log and nothing like that. You need something new because everybody else tried and they did the writ of habeas corpus. What's the name? What's that? Tabajet Zulu came in there pro se and did some messed up thing because of try to finish what the brother
Tashaka?
Right. He attempted to try to do a post-conviction type of remedy, but it was done incorrectly. Tabajet joined in. None of these people are attorneys, and she moved in pro se with some old BS if you looked at it. So apparently that didn't work. Notwithstanding the fact that those remedy for post-conviction is over, according to law, 1 year after sentencing. However, it's been 23 going on 24 years. All this other stuff, people are just trying to sound good. I know about the case, blah, 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 blah. Give me your money. That's what it is. If you don't do your research, they run in circles around people, and they're becoming more and more bold with their lies because they're used to doing it for years. So nobody actually questioned them. Nobody actually say, "Hold on, man, I put money in there. Here's the invoice. I want my money back, or you're going to court." Nobody's doing that. Cool.
Okay, in a Rico conspiracy, the most serious underlying racketeering activity is used in determining the offense level applicable to the underlying racketeering activity and need not involve an overt act personally committed by the defendant. Rather, it may be set by conduct of others. That is is
it may be said by conduct of others.
Foreseeable result of a defendant's involvement in the criminal enterprise. Burden of proof for uncharged underlying offenses. In some cases, a jury verdict may not indicate which of multiple underlying offenses were found to have been committed in furtherance of the RICO violation, or the jury may find some of the charged underlying offenses were committed but not others. All right, there also may be additional uncharged underlying offenses that may be accounted for as relevant conduct in determining the offense level for the underlying racketeering activity. And what does that mean in terms of coercion or manipulation from others kind of thing? Is that what that bit means? Like if you're encouraging someone to do something, does it
You can be encouraged. It doesn't matter whether you was encouraged to do it or whether you was affiliated, you was a part of it. If you notice in the subsection above all of this, you'll notice that you can be coerced into doing it, you still did it. You can be, or you can just not know that you're committing it, you're still guilty.
You still did it.
Affiliated. You can be affiliated with somebody and have nothing to do with it, but you purchased, you add money to the organization, you can get in trouble, or you can be questioned. And that's going to be determined based on the jury, whether or not they're going to hold you accountable or not.
Okay. The majority of circuits have held that uncharged or acquitted underlying offences, in example, predicate acts, may be accounted for as relevant conduct if the court finds the underlying offence has been proven by a preponderance of the evidence. These circuits reason that unlike a multi-object conspiracy, which is treated under S1B12D applicable guidelines as if each object constitutes a single object conspiracy, a RICO conspiracy is a single object conspiracy to engage in racketeering in violation of Section 1962. That is, the underlying acts of racketeering in a RICO conspiracy are not considered to be the object of the conspiracy, but simply conduct that is relevant to the central objective, participating in a criminal enterprise.
Remember, we're talking about the bottom line, the baseline? Hold more weight is greater.
Sure.
So it doesn't matter. It does not matter. It says conspiracy to are not considered to be the underlying act of racketeering in a RICO conspiracy.
As a single object conspiracy.
As a single object.
But rather central objects. Okay,
First thing that the attorney said to me was, man, I don't think people understand why about racketeering. Most attorneys are afraid of racketeering. You gotta understand why. You could assume that all of the defendant's properties and everything belongs to the state, to the government, right? All the monies and everything that is made after conviction or before conviction, it can be forfeit, all your properties and everything. So an attorney will look at a defendant like, where is your money coming from? Because they could come and take that shit from you. Attorneys are afraid of racketeering because before you go to court, you're already trapped on all levels, everywhere, and everybody that you dealt with, and everybody, all of that, they can use all of that against you. Okay.
Yeah.
So it's kind of hard. You notice that most people that got racketeering, they never win the case. They took a plea. Look at Young Thug. You follow that? Please. The attorney be like, hey, just take a plea real quick. I don't want to L on my record. Got your probation. Just go with it. So, yeah, racketeering is a beast. The RICO is a beast. Adrian Patrick made a music video called Stay Out the Way, talking about RICO. He did that specifically because we are to work on a documentary. And people need to understand what racketeering is. And this documentary is to clear the master teacher's image, name, etc., going through everything from beginning, the way we started, all the way into the court and what really happened. First thing he said to me was like, "Yo, man, that racketeering is crazy. A lot of attorneys don't want to deal with racketeering. It's like an octopus." Then I had to do my own research and start studying, and I was like, "Oh wow, whoa, that is a beast." And they can get you for anything. So I'll be looking at even, they can get you for anything. Gang activity, all that. Cool. All right, so based on what y'all hear so far, let me hear your thoughts.
Well, my thoughts is they can basically get you on things that you haven't even done. That's my thoughts, but you know.
Wait.
Yeah, they can get you on things that you didn't even know that you were committing. You're innocent. You're like, I'm with the movement. This person sounds very passionate and sincere. They got their cheerleaders vouching for them, so that must be true. No, that doesn't mean it's true. We don't go like that. We don't deal with that. We deal with evidence, experience, reasons. Reasoning, right reasoning. So when you look at it, and you look at the new name over an organization, but yet they implicating the master teacher, putting his name in everything, as if the government don't see everything, whether it's on television, on the phone, on the computer, or just in your neighborhood, just in your surroundings, and implants. You're gonna have to wonder, how much further you're willing to take this type of behavior, this type of mindset, just believing things without knowing, without questioning, and just giving your money and think all will go away, and repeating it, doing the same thing over and over and expect the same result. This is starting from year 1 of the 23, all the way to 2, 3, 4, 5, 6, all the way up to 23 times new lawyers from Africa. He's supposed to get out. He's a diplomat. Does the United States recognize him as a diplomat? Which is a question I did ask.
No.
No, the answer is from them. So if the United States does not recognize him as a diplomat, here's the reason why he's still in there. The reason why he's still in there. We're gonna have a court date on the 14th. We should, we'll give you an update. He's going to court. Do you hear any results from it? No. We're gonna, I'm talking about the legal side. We're gonna do this. We need more money. We're filing this, we're filing that. That is a gimmick. Master Teacher even mentioned that. Why give people money so they can just play the game of we gotta file this and file that? They're waiting him out. They're waiting the Master Teacher, relying on his old age to overcome him. This is what's really going on. Have the entire family put their mind together. Say, I don't want nothing else that y'all got right now. We need to get the Master Teacher out. I don't want to get no books from y'all, no new stuff, none of that. Think about how the Master Teacher may feel. Sitting in there in that little box for 20-something years, and you're coming like, what's the new doctrine? What's the new doctrine? What's the new doctrine? And he's like, what's the update on my release? What's the update on my release? What's the update on my release? For those who heard the tape of me, the recording with him. You hear him say it several times. I'm getting old. I don't have much time. And they begged me to take it down. They begged me, please take that down, please take that down. Why? So nobody can hear the master teacher profess his love for his children. Nobody can hear what he's really going through. So all of these people that are putting their money in can't hear his voice one more time. Can't hear him, can't get an update, can't have transparency. Is that what it is all about? Y'all can miss me with that. And I'm gonna tell you this. People have been putting money in for years and have not gotten results. I don't know why they continually support that same group that they put money in to and not getting. If you don't get no result, do something different. Stop repeating the same thing over and over and over and expect different results. Next year, he's about to be out on Savior's Day. Year after that, he's about to be out. We found another lawyer, a Booga Booga lawyer, that is talking with the country over there that says that he is this and that and the other. Does America, the big bad wolf or eagle, recognize it? That's the bottom line. He's in America. Okay? So that's just a little piece of the Rico, so y'all can get in a little bit of understanding of how serious the situation is and why you may find me saying I am not dealing with them. It's not a hater thing. It's a reality thing. I am not affiliating myself with that. I am not going around that. I'm not going to be a part of that which is putting my father in more danger, gaining more time. Not only that, families losing people, children may lose their parents because they are involved. As you read, you could just be affiliated. 20 years. And the charge and the fine, $250,000 to $2 million. Don't believe me? Do your research. Master teacher always say, right? Don't believe me. Check it out. The master teacher said, don't believe him. Why should I believe y'all over there that's running stuff? Action speaks louder than words, right? You get that wow, W-O-W, works over words, and your works have shown no results that benefits the nation, the master teacher first, and his freedom. None. All of it is a smoke and mirror, a light show. It sounds good. Get back to your holy tablets. You Nuwaubians, get back to your Nuwaubian way of life. Question things. As we always did. Hold on to that rope. Because anything after his incarceration, while he's under duress and implicated and compromised, anything after his incarceration needs to be questioned, and it is questionable. The bunch and whatever outside of that, second-hand, third-hand books that is coming out from second, third, fourth-hand people that make mistakes, and people that are money hungry, and people that's been lying over the years is not something that I want to touch or put my hands on. I'm sticking to what he told us while he was in front of us. He told us who his mother was over 40 some odd years. He told you where he was born. He told you where he's from. You understand? He told you where his father's from. All of a sudden, my grandmother is a liar. And she kidnapped a child from Ghana or somewhere. All of a sudden, the master teacher has been lying to us for all these years, and wait until he get under their control. They waited till he get under their control, right? To start lying. That's when he started coming out with the new doctrine. As soon as they capture him, all of a sudden, everything changed. He's been lying for all these years. Huh? He is not Sudanese, he is Guyanese. Or his mother is not, related to Ben York, Sitzkawea, the Native American side of things. None of that matters, the Yorks. All of that is a lie, huh? Now all of a sudden, his real mother is in Ghana. Why? That's a deadbeat mother that just got that. She's not qualified. She gave a baby. That's a lie. And there's way more other stuff. I ain't trying to overflow people's mind with all of that type of negativity. We should look forward to using the knowledge that you have and acquired after your research to come up with a good plan that we work together, of and for and by each other, and facilitate his freedom. We have to get land. He said get everything back. We have to rebuild. That's the formula. That's the ingredients. Because when you get out, where he's gonna go? You have to rebuild the Muharraj. Why? Then read the Black Book. You'll find out. That's the sacred record of Atum Re. Because an Afirti or Pharaoh must regain his Atif, his crown, every 30 years. So he needs to be out before 2030, or before the 30 period of time since the Zed Festival, the Osiris procession, the Atif Osiris crown. That's what it's about. The master teacher said, why in the Holy Tablet, why couldn't I be sent to the ants? The ants will never stop. When you step on their mound, pyramid, they rebuild it. And they go at whoever tried to destroy it in the first place. They don't go back into the nest and ask the queen for some pots of rocks while we are at war on the outside, coming in at us. That's crazy. All right, cool. So, anybody else got any comments, questions, concerns before we end it with the all affirmation? All right, let's end it with the all affirmation. So we're into 10 for showing up. It means thank you all for showing up. We'll be here, same time, same channel, tomorrow.
Oh, can I be heard?
Sure.
Begin our thinking prayers and deeds with who? Divine love in the all. Abdor ku pazun tafulat wadanubat mafu hadus ashuk fi anakalu. I am in the love of all, and all love is me. Anuki fi ina ashuk shel kalu wakol ashuk kaloni. We are all in all. Na asakuna fi kalu. I am a part of all, and all is a part of me. Anuki farugun shel kalu wakalo kalon farugun shelni. I am one with all, and all is one with me. Anuki wahid karkalu wakalo kalon wahid maahni. I can succeed as part of all and fail as an individual. Nuka kilo anjihu kama farugun shel kalu wakob kama faridun. I can be all that I wish in all, as long as my wish is to stay in all. No kakilu wakwino ko tik no kakfizu fikalo kama tawol kama kafati kalonia ahmidu fikalo. I am never alone. Anuki kabahawahud. All is I am. Talo kalon anuki. All can I can. Talo yakol no kakilu. All does I do. Talo bamol no katmilu. هو معنا منفر الشعب.
Kaun fi.
Peace in the land is truly wonderful.
Well,
Kaun
mine.
fi. Huamana, the fiddle shot.
If you said, why do it?
I sure what do.
Ashok Wadu.